Good morning, and thank you for joining me on the path to liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the Fast Friday edition of the show for October 27th, 2023. And I got tagged in a post this week where they were asking people what they thought was the most important of the 10 amendments in the Bill of Rights. And I should set aside the fact first, because I think you guys are going to know where I'm going to take this. I should first set aside the fact that I absolutely agree that there is one right, one natural right that we get by the nature of our birth that is there to defend all of the others. But that right does not come from the Bill of Rights. It exists whether we had a Constitution or a Bill of Rights or not. So let me share with you some views from the founding generation that might shed some light on where I come from on this. Here first from Thomas Jefferson in his opinion against the constitutionality of Alexander Hamilton's horrible national bank in 1791. He said, "I consider the foundation of the Constitution is laid on this ground, that all powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people." This was 10 months to the day before ratification of the Bill of Rights, and Thomas Jefferson is hammering home that he sees the 10th Amendment as the foundation, the structure of the entire Constitution. What is not delegated is automatically reserved. And John Jay, in A Citizen of New York in 1788, had a very similar view. He said the Constitution only serves to point out that part of the people's business which they think proper by it to refer to the management of the persons therein designated. Probably not how I would have written that sentence, but anyways, John Jay continued. Those persons are to receive that business to manage not for themselves and as their own, but as agents and overseers for the people to whom they are constantly responsible and by whom only they are to be appointed. Now, there was a big reason why this structure of delegated and reserved powers was so important, was so foundational, not just as an add-on, but to the entire structure of the document. It's actually a legal rule of construction. It tells us how to read the entire Constitution. The Ninth Amendment is one as well. But the reason is that so many in the founding generation, a vast majority, of course, there were outliers like Alexander Hamilton, but a vast majority of the founders, the framers, the founding generation saw consolidation or centralization of power as a massive threat to the liberties of the people. Patrick Henry thought it was the greatest danger. And he railed against consolidation over and over and over in the Virginia ratification debates in June of 1788. Here's a couple of quick examples. June 5th. There's one thing in it which I never would acquiesce in. I mean, the changing it into a consolidated government, which is so abhorrent to my mind. Just absolutely abhorrent is the idea of consolidation. And on June 7th, he said, dangers are to be apprehended in whatever manner we proceed, but those of a consolidation are the most destructive. And he said also, consolidation must end in the destruction of our liberties. He said it's absolutely guaranteed. Now, it wasn't just Patrick Henry, not even close. I covered this opposition and this concern about consolidation as a great danger to liberty in a recent episode, Strike the Root Consolidation. If you understand the root cause of the problems, you can address that. Otherwise, you're just hacking at branches. And if you prune, a lot of times the branches grow back much stronger and things get worse. So you have to understand that consolidation, centralization of power is the source of so many of our problems, if not all of them, as Patrick Henry warned about. And that we'll link to that in the show notes. Of course, Alan Mosley organizes the blog post for every episode. I get that finally published a couple hours after the live stream is done. That'll be over at 10thamendmentcenter.com/path-to-liberty, where you can find this episode, this other episode, and all the original source documents that I'm mentioning in this episode. I covered in that one the views of other leading founders, Federalists and Anti-Federalists alike, not just Patrick Henry, but also William Davey, George Mason, and a few others. Now, Mike Maharrey put it this way, quote, "If consolidation ends in the destruction of our liberties, as Patrick Henry put it, the key to regaining liberty is unconsolidation, or to use an actual word, decentralization, the system of federalism that is reinforced or affirmed by the 10th Amendment to the Constitution for these United States." John Taylor of Caroline, the great Jeffersonian, in Construction Construed and Constitutions Vindicated 1820, the whole thing will be linked to, you can read it, that'll be in the show notes, pointed out that this is the way you secure or preserve liberty. He said, the preservation of liberty must depend on the division of power between the state and federal governments, or an accurate distinction between the powers bestowed and reserved. And I know I'm citing a lot of Virginians here, Jefferson, Patrick Henry, John Taylor of Caroline, but it wasn't just the Virginians. And I know I mentioned John Jay as well. Up in Massachusetts, ratification in early 1788 was almost certainly going to fail. And if it failed in Massachusetts, it was probably going to fail in New York, New Hampshire, Virginia. The Constitution would have been dead in the water. They were whipping votes and they were tallying up, and the votes against were pretty solidly in the lead. So Federalists, primarily people like Theophilus Parsons, Rufus King, and a few others, they worked out a deal with John Hancock and Samuel Adams. We know that John Hancock was probably drafting some proposed amendments to the Constitution pretty early on, even before the ratifying convention in Massachusetts. And so the proposal and the strategy was, okay, we'll agree to ratify, but we're going to recommend amendments. And you are going to agree, because we are brothers in arms, you're going to agree to go along with this. And maybe we won't get all of these amendments, but if we start this process and all the other states start doing this, we're going to end up with amendments to the Constitution or a Declaration of Rights. And actually, in many cases, probably some people wanted both. Now, here's the absolute number one thing that Massachusetts recommended for ratification. And mind you, we know, and there are some letters discussing this in 1789, when there was a delay by the Federalists to actually propose the amendments, we know that everyone was aware that the Constitution probably would not have succeeded had it not been for this approach. So Hancock's first one, well, we'll call it John Hancock's, was this. First, that it be explicitly declared that all powers not expressly delegated by the aforesaid Constitution are reserved to the several states to be by them exercised. So without that recommended amendment, a precursor, it's not obviously the exact same thing. It's based more on the Articles of Confederation. Without saying there's delegated and reserved powers and there's a clear line in the sand, the Constitution wouldn't even exist, most likely. It probably would not have passed. So that's incredibly important. That was in February of 1788. And then in June, New Hampshire used the exact same language. And the number one thing for their ratification was also that it be explicitly declared that all powers not expressly delegated by the aforesaid Constitution are reserved to the several states to be by them exercised. Now, Samuel Adams was getting a little stressed out. He put his name on the line saying, we're going to ratify. You Federalists, you're going to agree to do this. And then if they start stalling in 1789. He starts writing to some of his friends later in the year. Here to Elbridge Gerry, August 22nd, 1789. He said, those who I call the best, the most judicious and disinterested Federalists, who wish for the perpetual union, liberty, and happiness of the states and their respective citizens, many of them, if not all, are anxiously expecting them. That is, amendments. They wish to see a line drawn as clearly as may be between the federal powers vested in Congress and the distinct sovereignty of the several states upon which the private and personal rights of the citizens depend. So the number one thing he's like, hey, you guys in Congress, we got to get this done before Congress adjourns this year. We need to get this, and we need a line in the sand between delegated and reserved powers. Samuel Adams continued, without such distinction, there will be danger of the Constitution issuing imperceptibly and gradually into a consolidated government over all the states. He had a similar take to Richard Henry Lee, who was in the Senate, 2 days later in 1789. He said, I mean, my friend, to let you know how deeply I am impressed with a sense of the importance of amendments, that the good people may clearly see the distinction, for there is a distinction between the federal powers vested in Congress and the sovereign authority belonging to the several states, which is the palladium of private and personal rights of the citizens. So to Samuel Adams, The line in the sand, just like John Taylor of Caroline said years later, the line in the sand between federal delegated powers and reserve powers to the people of the several states, that is the palladium of the private and personal rights of the citizens. That's the way you can defend yourself against an encroaching and usurping power general government. In New York, they had a very similar approach. They had their version of a precursor to the 10th Amendment, number 3, but it ties in very closely because it is about delegating reserve powers. And if power flows from the people, they're delegating. It ties in with their first one as well. Let me read it all to you here. That all power is originally vested in and consequently derived from the people, and that government is instituted by them for their common interest, protection, and security. And so then the third on that list is, these are their recommended amendments when they ratified in July of 1788, that every power, jurisdiction, and right, which is not by the said Constitution clearly delegated to the Congress of the United States or the departments of the government thereof, remains to the people of the several states or to their respective state governments to whom they may have granted the same. So in New York was also a very close vote, even after Massachusetts. It may have lost there if they weren't able to recommend amendments. And right close to the top, if not very top, depending on how you read this, is another precursor to what became the 10th Amendment. In Virginia, they took a little different approach. They also recommended amendments. Of course, Patrick Henry was really pushing for a Bill of Rights. He wanted to see amendments in advance. He tried up to the very last minute to get a list of amendments that had to be included, but they ended up ratifying with recommendations. They started out with a long list that would what they wanted to see as a Declaration of Rights. And then they wanted amendments to the body of the Constitution. Now, when James Madison made his proposal for the Bill of Rights in June of 1789, he actually included what became the 10th Amendment, along with a separation of powers statement as a recommendation to be a new Article 7. He thought it was so important that it needed to be in the body of the Constitution, and that comes probably from the Virginia ratifying document here. June 26, 1788. First, that each state in the Union shall respectively retain every power, jurisdiction, and right, which is not by this Constitution delegated to the Congress of the United States or to the departments of the federal government. That's the first amendment that Virginia recommended in their ratification document, June of 1788. North Carolina used the same text in their approach the following year. In South Carolina, they're a little wishy-washy. They only include their kind of 10th Amendment precursor second when they ratified. They said, this convention doth also declare that no section or paragraph of the said Constitution warrants a construction that the states do not retain every power not expressly relinquished by them and vested in the general government of the Union. Now, some people thought the notion of clearly saying that there's delegated and reserved powers was in and of itself the entirety of a Bill of Rights. And that's how James Wilson put it. A Bill of Rights annexed to a Constitution, is an enumeration of the powers reserved. And that's really basically saying that if you're telling them that they only have those powers delegated to them, they can't do any of this other stuff that's not listed there anyways. That would have been James Wilson's argument against even having a Bill of Rights. I'm trying to pull up another quote from Richard Henry Lee. I don't know if I can get it on the screen here, but give me just a moment. Here's how he put it. No power should be exercised but such as expressly given, and therefore no constructive power can be exercised. To prevent this is the great use of a Bill of Rights. And then one more here from Samuel Adams. This was on February 1st, 1788, talking about the proposal that John Hancock had introduced, recommending these amendments. He said, Your Excellency's first proposition is, quote, that it be explicitly declared that all powers not expressly delegated to Congress are reserved to the several states to be by them exercised. So again, this is the precursor to the 10th Amendment from Massachusetts. And Samuel Adams put it this way. This appears to my mind to be a summary of a Bill of Rights, which gentlemen are anxious to obtain. So in and of itself, some people would say the 10th Amendment on its own could be a Bill of Rights because it clearly points out that if they don't say anything about powers over free speech or the press or the natural right of self-defense, the right to keep and bear arms, things like that, then they don't have that power anyway. So the 10th Amendment could be read on its own as an entire Bill of Rights, according to people like James Wilson, Samuel Adams, and a few others. Now, closing it out here, I think John Hancock has a great statement. He said, "The powers reserved by the people render them secure." He pointed out that it is the reserved powers of the people that can keep them free. Now, of course, it's up to the people to use those powers that have been reserved to them, people of the several states. They use the powers reserved to them in ways that support the Constitution and liberty instead of how they've been using it for generations and generations, and that is in support of more and more federal power. Well, I hope you guys found this interesting. It was educational. I hope it made you think a little bit. I really appreciate you being here. If you want to help us get this kind of message out to more and more people, this kind of history, this kind of information and education, absolutely nothing helps us do this work every single day more than the financial faith and support of our members. You can join us for as little as $2 a month over at 10thamendmentcenter.com/members. No pressure, but it would be absolutely awesome if you threw a couple of bucks of that dirty government fiat our way. Our membership program starts out at just $2 a month. We also have annual, 5-year, and lifetime options. Again, 10thamendmentcenter.com/members. Quick programming note, it's possible I might not be doing a show on Monday. It's my 20-year anniversary this weekend, so it's possible I might not have some extra time, but we'll see how things go down. And if I'm not around, no sweat. I'll be back to my regular schedule on Wednesday and Friday. Again, I really appreciate you being here. I hope you have an awesome weekend, and I look forward to seeing you next week here on the Path to Liberty.